Anyone with an IQ above 80 can see very clearly there were no witness testimony, there was no evidence, and she did not submit any challenge to the jury instructions on the RICO cause. Therefore, it's not even going to be considered by the appeals court. Therefore, you have nothing to take to the Supreme Court. If you did not argue it in the appeals court, if you did not have witness, evidence, or challenge to the jury instructions, you have nothing to take to the Supreme Court. And anyone who is not special needs can see that. A prerequisite for saying Robert Kelly is not guilty of RICO is the challenge to the jury instructions in front of Judge Ann Donnelly. That's what Appellate Judge Sullivan is stating to Baumjean, that was not done because she didn't put it in her appeal, even though Thomas Farinella did challenge jury instructions, which is in one of the previous videos. The first time appeals court Judge Sullivan says jury instructions weren't challenged.
I guess I'm trying to understand, are you challenging the jury instruction, which didn't say that the RICO enterprise had to have an illegal purpose?
A prereq to raising the argument at the appeal level is that you brought it up at the lower court, which it was brought up. Thomas Farinella brought it up. She failed to put that in her appeal brief, so they are unaware that it was brought up, so they're saying you can't make the argument here. The second time Judge Sullivan brings up challenging the jury instructions.
So I guess A, what's the authority for that, and B, isn't that really a challenge to the jury instruction? Or did the district court tell the jury that they had to find an illegal purpose so there could be no enterprise? I guess I'm asking a basic question to start with.
They're not even considering her argument on RICO because she never put in her appeal brief that jury instructions were challenged, which was a prerequisite to making the argument at the appeal level. The third time Judge Sullivan said she didn't challenge jury instructions.
They want to read out organized crime?
Yes, because this is not an organization simply with a criminal. And that is what the government is asking the court to find here. I believe my time has expired.
But I mean, you're not challenging the jury instructions, so you're agreeing that everything the district court told the jury they needed to find was correct, right? So the jury wasn't asked to read out portions of the statute.
Again, I go back.
The jury was correctly instructed. So I guess I'm trying to figure out, you're saying that the evidence didn't support the elements that were correctly instructed to the jury.
Judge Sullivan is saying you're making an argument at the appeal level that you did not challenge in the lower court. Therefore, you didn't do the prereq work, so we can't even consider your argument. The fourth time Judge Sullivan refers to objecting to the jury instructions.
You didn't object to the jury instructions.
I didn't.
Your view is that that's a wrong instruction? You're conflating the fifth and the first elements of a RICO claim. You seem to be flipping that into the enterprise, and I think that's where you're getting confused.
I believe Jennifer Baumjean was hired by Keith Raniere to do her appeal for his NXIVM case. And then 30 days, a month later, after he read her appellate brief, he fired her. I believe that's what happened. You guys can look that up. Tom Mesereau's work laid the foundation for the appeal for Cosby, bringing in an appellate lawyer, Becky James, who filed all the right motions, did all of the preserving of information during the trial to make it so simple for the appeal that even a first-year law student could have won that. Cosby's win at the appellate level is directly attributed to Tom Mesereau's work. She lost Cosby's civil case. She put a motion 29 and 33 in front of Ann Donnelly in R. Kelly's sentencing report that was brutally dog-walked by Judge Ann Donnelly because of its ineptness, apparently. She filed a motion in the Illinois trial about getting information for the BOP, but she didn't tie it to the Illinois trial by using Rashauna's name, which I put Rashauna's name in my email to her. So she didn't tie it to Illinois, so the motion got denied. But she submitted a screenshot that had 8 lines, 6 of which pointed to witness intimidation. And that's what prompted the government. The government responded the very next day to impanel a confidential jury. The day after that, where the judge granted the government the confidential jury. Bonjean submitting a screenshot pointing to witness intimidation prompted the government to file a motion for a confidential jury and had a hearing August 3rd where the judge allowed the confidential jury. Robert's lawyer is the one that got him a confidential jury. They all wanted to take credit for bringing Bonjean to R. Kelly's case. So take a bow. He who controls the money controls who the lawyers are. He went from holding an umbrella, carrying the umbrella for R. Kelly, to living a millionaire lifestyle since R. Kelly has been in. What a lucky man. Oh, did I mention that he has a restaurant now with his brother and his best friend? I believe word on the street is he put cash up to hide his involvement.